families. But I think it has to be connect them and we have a lot give us good in this world, good in the protect us from the darkness and you guys family. So we all want good in this world as well. Part of that good is that we gain what is supposed to be family and when we reach our age, we find ourselves with all this pain and wealth inheritance that is supposed to be left by families. That was never our wealth that we put in there. Food and nothing for that. So the better to leave your family well off to go back to leave this world, but to leave them in a difficult situation. It's really important that when we get to this part of our lives, we start thinking about how we can the father will see it. That is into our inheritance. I want to see us a little while today on how we were supposed to do access to parents and relatives. That is also the father will see it. Who might that a person who has valuable without the impact of the will for the family to lose after. So today, alhamdulillah, we have with us in our CPA and Chowdhury. He has decades of experience in this field. And it's helping clients understanding what their difficulties are. And so it's how to really talk about that and what the legal complexities and the tax issues and things like that. So please make sure you pay attention. And if you have any questions you want to say it, I'll pass it to this one.
Assalamu alaikum. So, before I start, let me mention something. I'm a CPA, so what we do in order to maintain a license, we have to take 40 hours process. So sometimes you get excited to start talking. We are not really interested how we have to do it because in order to make a license, we get a 40 hours of computer. Maybe I also do like something like that. But I can just hear you, pay attention. You can learn something today, you can help you to save your money, and also you can save your family from the hassle. As you see on the slide, there are few things. Schedule, legal, consideration, and tax implication to the federal, the state level. State level comes from the talking about New York because we live in New York and most of us here, we live in New York. We came from various countries, yes. Fortunately, you have to think about the same level. Because in here, you don't have to worry about why who's going to get smart here in the system. You don't worry about it. But this country, if you don't worry about it, if you don't think about it, it will be distributed not according to Sharia, it's going to be distributed according to state law. That means you'll be accountable for that. Because before you die, as a non-nation, you got 2 days, you say 2 days, let's go by 2 days, you can have your work. Okay? So, 1 and 2, we are talking about distribution. Keep in mind, there are 2 concepts we're going to discuss today. Distribution, so we are talking Sharia law, you're going to keep in mind. Legal consideration, we're still talking about distribution. Second thing we're going to talk about tax implication. Some of the distribution can be taxable and some of them not. So when we come to tax states, we are talking 4 different taxes. State tax, income tax, gift tax. basic things. Three of them relate to the federal government, one of them relates to federal government and state government. So my today's seminar is not about to become expert on the tax or Sharia or legal. My main concern is for today, I want to give a better understanding so you know what to do before you pass it. So this slide basically, I want to just touch it. One of our local mosques they brought scholar and they brought a lawyer to discuss in Sharia and the legal side. Then I found it okay, there's another equation which we should know, which is tax. So that motivated me to come up with this plan. Okay, let's talk about work. There is 5 things you need in order to have a valid work. First of all, you must be over 18 years old, you must be studying, you must be writing, and then create your role in society in the presence of 2 people. Those are the 5 things in order to be balanced. Then one day we're going to, if you have goal, if you don't have goal, then we're going to discuss what process we're going to go through. So let's say if you don't have goal, we discuss in order to value goal you have to have 5 points, yes? Now, let's say if we didn't do anything, most people are dying without doing anything, yes? In our Muslim community, because people they don't know what things ahead of them. So let's say you are a career, which unfortunately most of us having this issue. First $50,000 go to your spouse. Reminder will be distributed equally to your children. There is nothing one side or two sides. It's everything that we apply. Let's say no children, only your spouse. Then only spouse will take over everything. So far we discussed two scenarios. No spouse, no children. And children will take support. And now, no spouse, no children. First, when I get it, parents, then siblings, brother, sister, then grandparents, or their grandparents, their descendants, or if you don't have more distant relatives. Look at this, those are the law of the New York State. How many scenarios? I've discussed 5 different scenarios. The number 5th one, if you don't have none of them, then state will take over your assets. Now your question to most people, few weeks ago, I went to one of my rental house in your neighborhood. The brother was talking about he was paying for a house, he was saying, okay, we have to get that. But one thing came in my mind that most of us were thinking, okay, I'm the one who's going to drive fast. That's okay. Let's assume the person is his wife and 2 children. One boy, one girl. He's thinking, okay, I'm going to drive fast. So my wife's going to get 1/8, my son's going to get 1/3, and my son's going to get 2/3, and daughter's going to get 1/3. I'm done. Based on most people going to think to make it move. Yes? This is wrong. Look at the state. You state uses in 5 different scenarios. Yes? Say spouse, children. Then say no children, only spouse, then you say children, no spouse. Then it's talking about no spouse, no children. So you have only prepare your will, you have to think about it. Then okay, what if my wife dies? What if my daughter dies? What if my daughter dies when she had children? What if my son dies? What if all of us die? You have to think every single scenario because nobody knows who can help us. Don't forget, we are living in a completely different environment. It's not a Bangladesh or Pakistan or India, it's on a Florida. This is a completely different environment. And you have to think about it. And this is very important to us. Okay, now we discuss if we have a will and we don't have a will. Unfortunately, both cases, we got to go to COVID court or surrogate court. Is when the person dies, or that is you got to go to surrogate court of that locality. And unfortunately, so when we are talking about wool and oil, but we have alternative choice. We will discuss later. But those two cases, unfortunately, for the wool or without in both cases, we got to go through the process to the court. Court is what is a public. Everybody will know what you have because it's public. So court is basically when you go to court, you're going to look at original death, people ask for original death certificate, or you can ask for years of beneficiary, so you can ask you that, okay, wealth, and those are the things you need to take it before you go to court. Yes, because we will have the executor, and if you don't have the call it administrator. Those are two different concepts they use it in order to understand easily which one is what. So you go to the court, yes? Think about it. When you take your vote to the court, who's going to get executor going to take vote to the court? Court going to look at all the information, the detail will, and there's a lot of costs associated with process. Court fees, lawyer fees, appraisal fees, and even most will, they do not mention about bond. So there's another issue there. One is 5% to 1% in the state. And goes on that one. That means in the terms, even the process your work. So code will look at those information, and once those code basically realize this is very clean, then code will process it. They basically do a citation. So code will issue a citation, basically code basically tells executor I approve it, what you want, your peers and beneficiaries. Yes. And God forbid if there is an issue with that dispute, so you might apply the Michael Jackson case, and it was a big fuss in the media because he didn't leave what which we're going to discuss, and he gets billions of dollars worth of assets, and it was a public news because he didn't have the things which we're going to discuss later on. So, like small state, okay, smaller state, less than $50,000. But if you have a house in your name, then you can go to the small store, which basically is shortcut procedure. So let's look at those are the things I mentioned earlier, that those are the process associated going through the process. It's very costly and time-consuming. And as I mentioned earlier, that most of the time when the people create the rule, they don't mention what the bond is silent. One is silent on the rule, so that means another issue could can excel for 0.5% to up to 2%. They're going to put it that means you need the cash flow. You need the money in order to process your let's okay, this is another thing for sort of that thing called time. This is recently it was prior to 2024 report from New York State. So this is one of the new things that exist in New York State. Basically, you have to put the trust. You transfer your house to the trust. Yes. And when you're done, you go to that beneficiary. Okay. So we're talking about what the alternative is. Alternative, we can create living trust. What is the benefit of living trust? Living trust, the benefit of this trust, living trust or irrevocable trust. What is the benefit? If you create a living trust, benefit is that you don't have to go to court. Nobody will know your business. Everybody will know your peers and beneficiaries at the executive whom you can assign. Okay? So we discussed about that. Now let's go to what type of asset going to be when it comes to the function. You got to go through the part of the probate court. Because as I said, a will without will. Both cases you got to go through probate court. Okay? That means everybody will know your business. Because you need to do your homework. Reluctant to state to process your will or no will, and that means the public issue. It's become a public issue everywhere. Everyone can know it because if they log in to the cyber code, they can find every single thing about it. Okay? So let's go now. What the main goal is? We're going to discuss about what alternative we have. As I said, the alternative that is being revocable process can create it on non-revocable process, global level. Let's discuss what type of asset is going to be part of distribution when it comes to products. Bank account. Most people have bank account their own name. Yes, that means it's part of the public code. If you don't do anything. Real estate title owned by one person. Yes, that means it's part of the public code. Personal property. Jewelry, furniture, car, move are part of the public asset. The asset list of the assets that as you going to come into the strategic code, that's going to be there everything. Investments, stock, or if you have an account for investments, all of them we are talking fully owned accounts. Now we're going to say which asset is not going to go to probate code. If you own jointly, let's say you own your wife own house jointly, that is not going to be, we're talking distribution, we haven't reached tax issue yet. So jointly own houses, jointly own account. Retirement account is not going to go probate code because retirement account, like most people work, so they go for 1K, any kind of retirement, 401K, IRA. Okay, those things do not go to probate code. Reason is that because before you contribute anything, they will ask people from and bring us occupation vacation. That's why those assets is not really part of probate code, but in part of estate tax. We're going to discuss later. Or table on debt. Let's say you have table on debt. Let's say for account owned by you, like open account with Citibank, yes? But you can do purely. What that will mean that so if I die, I'll go to the bank, tell them, hey, I want to put it pure. What does that mean? If I die, I want someone to take this money. That means that proof will be excluded from probate code. Okay? So whole issue, as we said earlier, both gotta go through the probate code. Basically, it's become public issue. Yes. Now, how can I avoid that probate? This is alternative I mentioned. Yes. What is the alternative? You can create a trust. And what is the benefit of the trust? First, tax compensation if we create a revocable trust. What is revocable trust means for us, you are the creator, you retain the ownership, you retain the control, everything belongs to you until you pass away. So if tax compensation, that is a distinction between you and trust, because that's why it's a revocable trust. Means you are the one who is sitting on the trying to see. But revocable trust, there's another tools out there, which is not for most of us. Maybe those are more people with a lot of money, they have a lot of tax spending to plan. Where you are not a driving seat. You are signing someone else who's going to sit on that chair, and you are the one going to run your show when it comes to management of the money. Okay? So, what is the revocable trust? As I said, you don't need to get a EIN number. Employer identification number. You don't need your social security number. That means tax process everything is same as it is. You don't have to change anything. Whatever you have been doing, same thing you are doing, nothing will be changed. But when you're going to die, obviously you're going to make it to go for things to get back to the past. So when you die, obviously you will accept additional evidence trustee. That is going to be trustee. So you will be the primary trustee, but when you die, there's the rest of you could have your right secondary trustee Then it is your son, your daughter. You can at least you need to put your for your safety. So let's say you die. Your wife will step in as a trustee. Trustee is thinking she will apply for it. Yeah, you know, because up until you pass away, everything was included on your social security number while you die. So you no longer do it. Your wife can step in, and then everything your every income you generate after the pass away, everything will go to the trust. So how to think it? That's the question. Okay. The creating and not funding the trust. Okay? So you get a draft, a trust, you can put trust, or living trust, or irrevocable trust. Yes? First thing, you have to, first thing, you're going to be an initial trustee, then you're going to make a people trustee. First thing, yes. Second thing is that you're going to now go one at a time, you're going to trust on your asset. So let's say first there's a house. So you need to transfer your house to the trust. Then you get the file the deed. Obviously, once you transfer, you're going to like local office now that works, and you can transfer the deed. Then when you buy the house, you buy title insurance. Yeah. Then you also use from your title insurance company. Then you have insurance, and if you have a mortgage, then you get a mortgage company. Okay. Then we talk about bank account. If your bank account, you got to go to the bank, you get to, hey, this is my trust. Now, you think that my name, instead of my name, put it in trust. Just like everything you need to change it. And let's say you're on the car, and you need to change your car to the trust. In that case, you got to get the vehicle, then the original title, or the ID, and trust document. And they will transfer your car to them. And obviously, you also for the insurance company, auto insurance, and that will change your car to like bill of sales, what I'm talking about, like other personal assets like furniture, jewelry, you don't have to let them know so long as you have listed that asset, but make sure they will change. And insurance, I'm not going to talk about it because it's good, but you got to keep in mind that I need a cash flow. When I die, all the police, in order to transfer it, I need to be available. What most can be able to do, that might call it the foundation. Then what happens when they die, obviously get a chunk of money from the assets of money. That now they utilize in order to fund the process and all costs. Possibly business. You're not actually into a business, you're transferring your business to the customer. After it's when you're going to die, because of the business, you got to get to profit too. So those are the things you got to, then obviously you got to keep maintaining records. Every time you have a new asset, you got to put it to the cost. Okay? And when it comes to your cost, don't make you, what about you to put it cost, make sure your cost is things like cost. Every brokerage system will show the cost. Because if you make the first time, it's going to fix problem for you. Okay? So every time you rule and notice there is a problem, and then we talk about irrevocable trust, irrevocable trust or living trust, and then we talk about non-irrevocable trust, which basically transfer asset to the trust, and you have no control over the asset of the trust, but trustee can run the show, but it can be people put the money out there, they're giving the life of giving your life because so long as it is on the patient is a trust of the patient. So this is the key chart I want to share with you. So let's say lose the control during your lifetime. If you remove, you have full control because you can change your rule anytime you want it. Yes? If you have no rule, nothing. But irrevocable trust, you have full control over the asset. Yes? Irrevocable trust, you have no limited control because once you transfer anything to the trust, in order to get it, you got to go to the court, a lot of process. It's not, that's why people use transfer any asset to irrevocable trust, you can choose twice, you can make a planning and then you do that. Probate code, as I said, irrevocable trust, You cannot, you have to go to the probate court or surrogate court. Or instead you have to go, if you irrevocable trust, you don't have to go. And irrevocable trust, again, you don't have to go. Privacy, first case, there is no privacy because it becomes public property. Because what I mean public is anybody can have access about you when you make a will or you don't make a will because it's not anymore in a private. But irrevocable trust, it is a private matter and nobody will know about it. Same thing against the irrevocable trust. Amended, yes, you can amend the irrevocable trust, but you cannot amend irrevocable trust. Obviously, you can do it. Asset protection, there is no asset protection. As you say, up until irrevocable trust, only protection has to be made in irrevocable trust. That's when it is only benefit you're going to get if you make it irrevocable trust. Cost and setup, they're obviously they will not making will. There's no cost because you don't have a will. Yes, removal can be cost because you can transfer all of your assets to the trust. It's going to cost you money, but believe me, when you die, it's going to save a lot of money. Number one, second, you're going to save the hassle of the family because it can go to a lot of profits. So believe me, do not take it away. If you do it, that is not a big problem. But so let me give you some tips. Let's say you don't want to do work. You don't want to do anything. But you can do duties, but then you also limited authority. Let's say you can trust a spouse, so then buy a house, you join an account, it's called joint. That means when you die, it's going to the second life, automatic. The problem is that during the lifetime, your lifetime, she has same equal right to which you have. That's the problem. Okay? Bank, you can have a joint bank account at all, and then POD, you can say for POD means when you die, you're going to transfer to the person, you're going to pay the beneficiary. Okay? Investment, so long as you can name the person, you have to do it. Some of the they will force you to do it, some of the you can do it. Like if you're investment account, you have to do it. You got to call them, oh, I have to put it in my die, I want to put it. But if you say you can still send the form, you need to fill out this form. Those is your asset is not really high, but you can trust your spouse. You can do it, but there's a problem. Let's say if you trust, let's say you legal asset to your spouse, and let's say the person spouse is 2 children, and the spouse doesn't give the children share, then you will also account for the death with that. Don't forget about that. Because you have a Muslim, you got to think about the next life first before thinking about this life. Okay? So let's as I said, there are 4 different types of tax. Foreign estate tax, state estate tax, income tax, gift tax, estate tax. So foreign estate tax, they say if you have 13.4, that's around $14 million. If you have less than $14 million, you don't have to pay any tax. Anything above $14 million, you get 40%. It's not a small number, it's a big number. New York State said, okay, if you have $7.16 million, less than that, you are okay. But if you hit $7.16 million above, then you can pay up to 16% tax. This is a big number. But New York has another law called tax cliff. What does it do is that let's say your work goes to 105%. 7.16, if it goes 105%, then the entire amount could be taxed. There is no exception. So they're called tax cliff. New York State has these things. So what is the planning you can do? You can give gifts during your lifetime. That can reduce your asset, yes. But unfortunately, New York State follows that. If you give 3 years, after 3 years, they can bring it back. Anything beyond 3 years is not a part of estate calculation. So up to 3 years, you are in danger. Okay? But if it goes beyond 3 years, then you're okay. That's not going to be part of your asset tax. Another thing to do is credit shelter trust. What does it mean? So let's say, as I said, your asset more than 7.16 million, which is your taxable in real estate, but less than $14 million, you are in between. Yes? So what you can do, you can create called bypass trust or credit shelter. What does it mean? It means that, okay, you have $7.16 million exposure, yes? So up to $7.16 million, you're going to take the money and you're going to put it in a trust. But you put your wife or children as a beneficiary. So what happens is that you save up to $7.16 million in your wealth, you're going to take tax in your state, and the rest of the money, which you can take the benefit from the trust, and any money belongs to her, once she dies, she can also take $7.16 million. So think about it, even though you're less than $14 million, but it's about the $7.1 million. Nowadays, having $7.1 million, you fill the 3 houses. Easily can hit that number. Do not forget the cash. Asset, they're going to look at its fair market value. The moment you die, they can step up based on fair market value, and they will take it. You're going to calculate based on the fair market. They're not going to look at your prospects when you, like, 10, 15 years to be bought it. They're not going to look at it. They're going to look at what is the value that they have that day. Okay, another thing when you put about 25% of the trust. Basically, they're saying that in the trust, you can transfer your spouse to someone else. Case is not going to be part of your estate. Another thing you can do is spend down asset, like people in your house to other things so that you can spend your money. Another beautiful thing you can do is like you can donate to the mosque. And that's going to reduce your value. And that case, you don't have there is no limit. Like when I said earlier that when it comes to the gift, anything like in 3 years it will come back. But if you donate to the mosque, you can donate to anyone. Yes, it's not a gift. If a donation is a gift, two different things. That case is not going to be part of your estate. Life insurance process, as I mentioned, most people they do it in order to fund their trust. So they buy insurance, what they buy goes to the trust, and they look it on you. Okay? I mentioned one New York State tax gift, which I mentioned the moment you can hit it, 1 or 5%, you're going to get it. There's another topic plus you can trade it. Now let's look at portability. What happened? Portability is a concept only applies to the Fed, it doesn't apply to the state. What it means that you get 14 million, 13.99 million, your spouse gets 14.99 million. I'm talking to 13.5 number. So when you die, there is a spouse like an election, she can take this 14 million when she dies. So your 14 million plus our 14 million, 28 million, yes? She's going to take it when she dies. So up to $28 million, she doesn't have to pay any federal tax, not New York State. New York State definition. But then you have to make an election. It's called portability. And that's what we're going to go over some simple tax things. Beneficiary do not pay estate tax. Who pays it? Person who pays. Yes? So your asset is over 7.16 million. But less than 14 million, you pay New York State tax, real estate tax. But you don't need to file estate tax because you're less than first order. Okay? But as I said earlier, retirement account, IRA, 401k, it goes to the beneficiary, but they don't pay income tax. Because estate tax, I don't pay income tax when they can take money out from those retirement accounts. Okay, the another thing is step-up basis. When you die, your assets going to go step-up basis. As I said, let's say 3 houses. You think, okay, I bought it $200,000, $600,000. So my asset is less than 7.1 million. No. When you die, you got to pay to against your houses. And if you pay to 7.16 million, then you are in trouble. Then you got to do tax bonus. That's the only option that gives you a flat. Then if they give money to the market, those kind of things. So if you will organize that, only way you can reduce it. Otherwise, when you hit 1 or 5%, you can stop on your state. Then there is no inheritance tax in your state from your Florida. trust taxation. So what happens when if you pay the trust? Yes. So when you die, it's supposed to this trust become a person. No longer you and trust is to be same person until you die. The moment you die, you become a person. So what happens if you apply for a year number and trust it with income tax until all assets from the trust gets distributed. You agree or not? Okay. I was talking about portability. Yeah? Portability is simple. If you don't, there's a complex calculation, you can go over it if you don't understand. But at least you need to know about it because, like, let me mention, if you think, okay, I die, maybe my work is $5 million or $4 million. Now do I need to make portability? You don't know what will happen to your wife. Maybe she will have 40 million, 50 million, you never know. So it's simple. That is, there's a phone call 706, you can do it. On the top of the internet set, I'm going to mention that one. And just write it down and fill out the form and just send it to the IRS. What happened? Now you take your 14 million, as your spouse 14 million, 24 million. At least you protect yourself to the flat level, but there is no portability when it comes to New York State. New York State doesn't allow that portability. Okay, I mentioned earlier that there are four different types of asset tax. Then I said income tax, then gift tax. So gift tax is if you give anybody $19,000. If you do more than $19,000, you get a file gift tax. And in that case, you will pay 19% $19,000. So any excess, you can use $13.99 million. Same amount for estate tax, same amount for gift tax, a huge number of them. Same amount for GST tax. I'm going to mention GST tax in later. Anything above 13.99, when you get a clear bottom rate is 18%, you can go as far as school. And New York is a good thing. New York State does not tax for gift, but only will pocket back. Okay, as you stated, the tax 0 to 10,000 is 18%. We are talking, those are the rates. These rate for estate tax, gift tax. All of them are the same tax. As I said, in the exemption amount, $7.16 million, yes, the New York State rate start was 3.06 and ends up to 16%. So it's a big tax. It's not small. Usually, the income tax in New York State is 6%, yes? If you make it as those because in New York City, you pay another 4%. So you guys pay minimum 2% tax. This declarations can go as far as 16%. Okay? What is the GST? There's another issue with GST. GST, we're talking about, let's say, as I mentioned to you, there are two types of trust. Living trust, which you have the control. Non-living trust, you get a irrevocable trust. Yes? You have control. You transfer your asset to that irrevocable trust. Yeah? And let's say if you put a beneficiary, anybody more than 27 years old, 37 and a half, or your grandchildren. Once you skip one generation, let's say you put it in a trust, okay, I'm putting trust my son, my grandchildren, my grandchildren on the trust. When you make a trust document, it's the beneficiary, those are the beneficiary. Then GST going to kick in when grandchildren or great grandchildren going to take money from that GST trust. But by the way, when you contribute to the asset to the trust, when you make an election get that, then your children or grandchildren or great-grandchildren are going to take the money, then they're going to pay the GST tax. GST tax is the same way. So gift tax and GST tax, both going to calculate the same for 7 hours. Okay? Estate tax is called by 706. There's two different, then you get income tax. Income tax, let's say when you die, so any income generated from your assets is the tax rate. And you get the tax on it. That tax will be progressive tax rate. Lowest is 1%, and highest is 7%. New York State obviously and studying 6% is as far as I believe in 1%. Okay, so then that's planning to as I said, maybe you can distribute your wealth during your lifetime, you can give anybody 19,000. Not the person doesn't need to be a relative. You can give 19 times twice without 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 using extension on. But that's what you can find. Let's say then if you from your own account and you want to use your spouse, then you can find it. But if you give $19,000 and spouse is another $19,000 full personal, then you are okay because spouse and you are two different person. Okay? But if you want to do it and you want to use your spouse extension, then you have to buy few times of time. And that file, that income should be record forever until you die. Because when you're going to die, and all the expenses so far being used, it's going to be accumulated, and then finally you can look at it and see that year, the year of death, that you're going to look at what is the expense of. But whatever expense you have taken, still will be expected. So as I said, there's so many things you can do. Escape tax and so many things you can do very fast, as I said already. But if you make it revocable trust, again, any asset sitting revocable trust is part of the asset. So next part also you can do it saving. If you have, you can avoid probate code. But irrevocable trust, here, if you get value, you must say probate code, also you can save tax. But that's why, as I said, it's depends on your wealth, that I would recommend find out what you have, sit down, see, go one over item by item. Some of them you can do it by yourself. And some of them you can do by yourself. Some of them you need a lawyer to do. But believe me, if you do, when you're going to die, your children, your spouse, going to need a lot of work. First of all, you're not going to be accountable for the death of that. You need a good mistake. The second thing, you don't have to go to court. So this is very important for you guys to think about it and do this kind of thing. And I will send this slide to our ground. If you need a copy of them, just give your email address and we can send a copy of them. So as I said, portability only applies to Fed, it doesn't apply to real estate. Okay? I think this is talking about portability. I mean, there is an issue about the portability, how to do that, those kind of things. How to calculate your portability is talking about. We said that one of the things I was mentioning is look, conditional desk, wrap for this IRS guideline 27, 2017 class 34. So let's say if you want to use the portability, you don't want to hire an accountant, or you don't want to calculate anything. There is 76. I think the top laptop 2017 that's 34, you mill around, make sure you put a pocket, that is what? You're going to basically your wife, what you're taking to the money you die, your wife will do it, your spouse will do it, basically some other person. Then the moment they do, and they're going to get that benefit $2 million, they're going to keep it under the time. This is a basic example saying what is a portability. Once upon a time, okay? So any other question because of as I listen to our seminar, but I try to cut it down as much as I can because of timing issue. Do you have any questions? You can see. We then class. Okay. Class 1 is first of all, you gotta go to the court. You gotta go to local surrogate court. Yes. Let's say one means you have benefit. Yes. You take it out. You mention the executor. Yes. And you will take the word go to the court. First thing who's gonna do, obviously there's a lawyer. Yes. Who's gonna look at the validity of the will and court says it's valid rule. Then they're gonna issue citation. Basically, they're gonna say, okay, you executor, you can go left your years and beneficiary know that you can allocate wealth according to the law. But do not forget lawyer fee, good fee, maybe that court can afford by the amount, it's another 1 or 2%. Yes, all fees also you have to inform the creditors. So that is they're going to say, we're going to publish the newspaper that the person dies. So creditor can claim. And also another issue that if there is a disputed use of beneficiary, there's another problem. Then court is not going to put a stop on that case to resolve the issue of dispute between beneficiary and use. Yes? That needs to be resolved before court even stepping go ahead and tell that to go ahead and distribute the assets. Okay? Another thing will be, I mentioned benefactors. You gotta be over 18 years old, you gotta be fine-minded, you gotta be inviting, you need to sign it for that person first, two things like that. You can also then to sign it in 30 days. It cannot be more than 30 days of that. That's the valid. Okay? Clear that? Well, if they look at the old asset that they are not on the signature, or they're thinking that's like years from say, no, this is the final way. Yes? Then when the document could be present and that means then the process. They're going to go over until they resolve the issue. Yes? Nothing will be distributed until everyone agrees. Creative beneficiaries, they all agree, okay, we expect that word, and we're going to follow that. Then the citation is the one citation issue, but if there is a dispute, that I have this new surrogate court is not going to issue citation. Okay? Because first we need to resolve the dispute first. Because what happened, the family dispute only really, Michael Jackson, as I mentioned, is one of the best examples of that because family is a big mess, it's a big mess. Okay? So let's say you have three beneficiaries, right? And there's a few of them say, no, we do not agree that because I want to speak to the final one. Now that I have another one, and they come up with another. Yes? So there is a dispute. So there is the issue. So that so long as beneficiary years settle the issue within themselves, court will honor. As soon as you submit a court going to look into that again, and once court is clear this is a solid will, then they will issue citation. They're not going to issue citation until they are. Yes, when you go to the court, yes, as I said, obviously, first I'm going to go with the local executive. The administrator is only applied that for all days. Okay? Okay? Because usually what happened that most people don't mention about this, especially other people, they don't even think about that. Okay? So that's it. That court feel okay, they do that's what do live in the community, executive in another state. Would feel okay because it is a local issue. Would feel like you are maybe you can do something wrong. So or maybe one of the beneficiaries is not physically disabled. Okay, everything one would look at those things because court main purpose is at the end of the day everyone gets their flesh. Okay, that's the purpose of it. And I think that can be avoided if you can completely creating fast and temporary you might think it's going to happen. It's not. It's going to make maximum $2,000 maybe less. Let's say, let me give you an example. Let's say you have, let's say a person has a wife and two children, another person has a few children, yeah? Find a common scenario and get a what you call classic one. And you can split the cost. And then what do you need to do? Some of the things, as I said, you can do by yourself. Let's say, change the bank, go to the bank, put it the bank on the trust name, or do most of the you get it, lawyer, maybe you can take a list and maybe go to the back office, find out. You can do a lot of things can be done. Because I think judge feel that you are a good person. Okay? So judge only difference better if you make a good mention and don't want any point. You mention it, but if you don't mention it, then the thing is higher. That is beneficiary. If they agree, now we don't want that. Then they can go to the lawyer and let them just charge you money. Because so long as everyone agrees, anything can be solved. Living fast, just as I said, living rule, interpreters, living fast is as I said, the classic definition. Living fast was the local same thing. Okay? And you, I say, yeah. Joint account is fasting. The only thing you can keep your children is tenancy cover. What is the tenancy cover is when you die? No. Your children are going to pick up. Your wife and children, they will step up and they will take it. But joint tenancy and title, but more you, those are the cases you say each person only 40%. That's the register. It's not 50, each person 100%. Means even when you're owner, if you die, automatically 7% take over 100%. But tenancy will come up. Let's say if I want to pay the wages, and if I have a house with my wife, so I have money, I cannot put this house in the trust. Reason because it's a joint loan. But if my house is joint tenancy common, that gives my one half. Yes, so 50-50, we want 50-50. That 50% would be part of that trust, other 50% would be hand name or access. But if you get this, let's say if you have any house, John Leon, you cannot put a trust. Before you put a trust, you have to change the deed. Bank is simple. You can go to the bank, you say, I want to change your name. No. Joint account is anything jointly automatically goes to startup spouse. Okay? Or startup person whom you join with. Okay? It can be your children, it can be your spouse, it can be anyone. But do not forget that thing is not going to exceed it from estate tax. We are talking distribution. Distribution one thing and tax another thing. Any other person? Say that? Okay, fast food. You combine, you cannot make combine. You cannot be one fast food. You can own property, tenants income. Then you can go whatever ratio you want to put it that portion to the cost, you should put that portion to hard cost. But if anything jointly owned, you cannot put it neither your trust or hard cost because it's the first thing you have to do, first thing you got to make it tenants income. You got to go to the change the name, and when you take join you want to tenants income on, that one is put your name, you got to put the plastic. But if you trust the wife, and it seems we're going to distribute equity area, take it a little bit, then automatically you're going to avoid a probate call. But at the end of the day, it is on our responsibility to distribute equity. She may not do that. Then you're going to be in trouble next time. According to Sharia, so far I'm not an expert on Sharia. According to Sharia, you can give anything to anyone during your life. You are not going to be accountable next time. But if you are in the deathbed, no. This I spoken to Mufti if I came to our worship. He said, no, during the lifetime, one third is only applied to the old method. Okay. You can get anybody you want. That's your process. Now, nobody has any. But when you're dead, you have it's not your enemy. No. When you make a move, that will be affected after that. Then you cannot violate the Sharia. Then you're going to be in trouble. Because the rule is going to be affected after you die, yes? That case, you can't change it. Let's say spouse is one daughter, the one son, spouse is one, a son, whatever, one third, and two third, a daughter get a one third. That cannot be changed. Okay? Because that's going to happen after you die. Okay? That's why you can't change it. Anywhere you want it is expected any state. But you have to understand, if you don't do anything, first of all, you're going to get problem that first more going to face that unjust because you because do your job. Now state say, okay, but I'm going to get $50,000 to your spouse, and then I'm going to get everything in distributed where I want it. Because state has it that those are the 5 steps I mentioned to you. And then when you're going to make money, you need to do those steps too. Don't just think you're going to die fast. You got to think, what if my wife died? What if my son died? What if my daughter died? What if my daughter died once she's living children? You need to know your own position. That's why I would recommend maybe one day you guys could have been the scholar like to give a couple of hours. Ask millions of questions. And maybe you can do my work over here the money until each every one of you understand all the different scenarios. It is very, very important thing. Believe me, do not ignore it if you want to go to that. Don't ignore it. This is very important. No, I am not a, this is not very different thing. I'm going to give my card. I'm a CPA, I do tax. This is more, I know that the tournament name, I initially I put it in Spain, and the seminar was presented in my local worship by a Mufti, and the lawyer name is Hamza. So, what I said, if you, I would recommend get a slide from you and go for it, and believe me, once Mufti highlighting Hamza, staff, lawyer, he's the one who presented legal side. And there is so many things. Once you know your position, you don't need to be Muslim. You can go non-Muslim. But you have to know it. I'm not talking about textbook. Any textbook you have to know the text. You don't have to worry about textbook. I want you to know that legal side, the Sharia side. Once you know the Sharia side, therefore I would recommend go over the side and think about your position. What happened if I what happened in my lifetime? Those are the things you think about it. Then you access the rules expert of Australia. Yeah. And you can do those work about it. You can go over it. But also do not ignore the stuff. Let's say, I know you guys are not, Alhamdulillah, Muslim are not poor. People who live in the long run, all of them are new. Okay? All of them are new. So maybe you haven't that New York State about 17 months. But you don't know. When you die, you might be. Because real estate going up, unbelievable. So I would recommend to go to do first line tells you what I need to do. I always tell like when I had staff, when I had people like to do that, the first thing then you can possibly make it more. What is the problem? So let's say you say I want to go home. When you say I want to go home, you know you're right now at baseline motion. You don't have to nobody needs to tell you. It's obvious. But when there is a problem, you need to know what is the problem. Those same concept, the same thing, this thing will be that you don't have to think about. Before you solve an issue, that's when you understand the problem. That's why I say you need to understand all what issue related to the and then think about. But I would recommend maybe you can do combination of everything, but I don't want you to put it in, live it there into your family to go through this trouble. I don't recommend that. Because then it's going to be costing more money. Social Security, there is no beneficiary. Social Security, look, anything you get government, there is a certain rules, yes? So let's say when you get it, Social Security, they said, okay, your wife gonna, if has 10 years of 40 credits, yes, you get she gets 40 credits, and that 40 credits generate lower than your amount because you get half of you, yes? If you show one is let's say 1500, and basic calculate our standard is to be in the part to previous part is to be okay. Is that I'm going to take my spouse farm and when I go 70 over the period of my one grow, then I'm going to see those things are done, no longer do it. This is what Social Security is based on guideline. You don't have to think about it. You die, stop, the spouse is 362, and since she doesn't have she doesn't work, she wants to claim, she can get a 75%, and to the 67, she can get bigger person. Which one? Which one are you talking about? Social Security? A Social Security that you know, then wife's going to get it, your children is less than 10 years, so they're going to get it. If you die, and your child is like 6 years old, 7 years old, they're going to get it until they become 18. And when they become 18, it's going to stop. Social Security, this is your life. Let's put it that way. I want you to check it. I think I can check it, but I think I would recommend not to use the beneficiary because it's completely. I would recommend not to use. Even though you if the dollar now is still under the use. No, what no, no. What happened then they done only to those kind of yes. It used to be before I think one time they can have some percent that loan can get what happened then people used to say, okay, you can transfer that account, your account, and even the shit, they can hold it and they can keep it forever. Now they say, no, 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 you can do it, they want to get the money. The window is 10 years. Except for that, they don't do. For that, anybody other unless the person is physically disabled and infection. In regular work, normally 10 years, you get a pick up in the 10 years. Okay? Thank you very much for attending. Assalamu alaikum.